Perfect. Good afternoon, everybody. I hope you're well, and welcome to this RBS and NatWest Mentors last webinar of 2023, Go Directly to Jail. For those of you who don't know me, my name's Paul Buck. I'm an employment law business partner, and I'm joined today by my lovely colleague, Lucy Coombs, who's going to co-host. We've got a fun-packed hour. We've been working with our guest speakers to try and get 70 minutes of content into a 60 minutes webinar. So I'm going to talk as quickly as I possibly can. You'll have questions. Please populate the Q&A. I've got Lucy on standby just to harvest all those questions to make sure that we've captured them and we can answer them towards the end of the webinar. When the webinar closes, you'll have a short survey. If you don't mind just completing that survey for us, it's really helpful. And what we'll do in return is send you a copy of the slide deck and a link to the recording. So populate as many questions as you can. I like to make sure that we've got Lucy as busy as possible. So let me introduce our two guest speakers. So today, I'm really delighted to introduce, we've got Chris Morrison, who's the head of Clyde & Co.'s UK Health, Safety and Environmental Department. And for several years, he's been recognised as one of the UK's leading health and safety defence lawyers. He's constantly ranked in the legal directories, including as a legal individual in the Legal 500 back in 2020. And Clyde & Co. are Mentor's preferred health and safety legal partners for our customers' health and safety services. We've also got our very own esteemed Kevin Connor. Kevin Connor is a relationship director and a senior health and safety consultant in Mentor. He's often one of our go-to guys. So enough of me going on. Chris, can I hand over straight to you? Oh. Chris, are you there?
Hi, Paul. It's saying you cannot start your video because the host has stopped it.
Okay. Try that, Chris. There you go.
Thank you very much. Thanks, Paul. Yeah, good afternoon, everybody. Thanks for the nice introduction there, Paul. In summary, I'll keep it short. I am a crime lawyer. I started my career in the police stations representing drug dealers, car thieves, burglars and the like before moving on to serious organised crime. That was many, many moons ago. And for the past over 20 years now, I've been undertaking this kind of crime, which I call posh crime. But we call it regulatory crime because it's the representation of companies and directors and officers and occasionally employees who are subject to any form of regulatory criminal investigation. And in this case, we're going to be talking about health and safety. Okay, can I have the next slide, please, Paul? Thanks. Okay, today's objectives. I'm looking, hopefully, to do those of you that need an awareness, confirmation that the UK health and safety regime is a criminal regime. Okay, it's the reason why Mentor used myself, my team. It's because we do nothing else other than criminal law, albeit this regulatory crime. I'm also going to take you through the individual health and safety offences. So a lot of the time we focus on the duties of a business, but the purpose of today is to allow you to understand how you as individuals may come into contact with the regulators and potentially be prosecuted through the criminal courts. Let's hope it never happens, but you certainly need to be aware of it if you are, as I say, in business and that you have got employees or you are an employee and they are at work. I'm also going to take you through the risk indicators that I associate with director prosecutions. That's built up over the 20 plus years I've been representing businesses and directors. And I will give you examples, unfortunately, of the kind of custodial sentences directors receive if convicted for these this range of offences I'm going to cover off. And then finally, I'm just going to take you through the corporate manslaughter offence and how I believe you'll see when we get there, but how I believe that anyone that has some form of managerial decision needs to be alive to that particular offence and how he could be caught up in an investigation. Okay, the next slide, please, Paul. Okay, here's the first offence I'd like to deal with. This is the offence of gross negligence manslaughter. And you can see the definition there. The offence of gross negligence manslaughter, or GNM, as we call it, is committed where the death is a result of a grossly negligent, though otherwise lawful act or omission on the part of the defendant. Okay, let's just break down that particular offence into its components. And please be assured, every single one of us can commit this offence, whether you are the CEO or a director, all the way through to an apprentice, the most lowly paid employee within an organisation. So nobody is exempt from this particular offence. So the components are, firstly, that the defendant, and that's an individual defendant, so not a company, the individual defendant owed a duty of care to the deceased. That by a negligent act or omission, the defendant was in breach of the duty which he owed to the deceased. That the negligent act or omission was a cause of the death, and that the negligence was a cause of the death amounts to gross negligence and is therefore a crime. Okay. Now, hopefully you can follow that. But I suppose if we're going to apply it in the I'd say in the health and safety world, and the kind of things I'd see it associated with, which could be, trench collapse, demolition work, people incinerated in ovens, people killed in explosions, fires, falls from height, reversing vehicles, all the kind of cases I see which are associated with workplace fatalities. There is a helpful case that I think will allow you to understand how an individual can be brought in to one of these particular episodes. Now, it's not a health and safety case per se, but it does relate to what was effectively a workplace fatality. It involves a case in a hospital in Croydon, and it's this case of Adamarco, which I've mentioned at the bottom. And there was a routine eye operation taking place, and the registrar who's in charge of the anaesthetics, they were switched halfway through the operation at a routine change in shift, and Adamarco came in and took on the role of dealing with the anaesthesia. And unfortunately, they failed to notice or respond to obvious signs that the tube supplying oxygen to the patient had become disconnected. And the alarms were going off at the 4.5 minute mark. And then by 9 minutes, the patient tragically went into cardiac arrest and died. And Adamarco, as the anaesthetist, was deemed responsible for supplying the oxygen, and he, as a result, was investigated by the police for the particular offence of gross negligence manslaughter. The 4 components that we've just been through were all applied. Did the defendant owe a duty of care to the deceased? Was there a negligent act or omission on the part of the defendant, which was a breach of the duty owed to the deceased? Was that negligent act or omission the cause of death? And was the negligence, which was the cause of death, did it amount to a gross breach and was therefore a crime? And the prosecution, the police, in conjunction with the Crown Prosecution Service, they clearly believed all 4 were ticked off there. So they prosecuted it, put it in front of the court. I'm about to say it wasn't difficult to prove the first 3, bearing in mind the role that they had. But it came to this final point, and that was left to the jury. Effectively, the jury had to decide all 4 points, but the jury needed to decide whether the negligence was so gross that it amounts to gross negligence and is therefore a crime. And on that occasion, the jury decided, yes, it was. This was a gross breach and it is therefore criminal. As a result, Adamarco was convicted. And we now know that as the Adamarco test. And it will be applied by the Crown Prosecution Service and the police when they decide to prosecute. And when we actually get into courts, then that's what we've effectively the hurdle that we know we've got to overcome when defending a client who is effectively being prosecuted for this offence. Now, the maximum penalty there you'll see is potentially one of life imprisonment. The reality is that the range is 1 to 18 years imprisonment. And could we just have the next slide, please, Paul? This is the table that the judges actually work from. And you'll see that it is a range of culpability. So that's how far below the standard the defendant fell. If we move over to D, well, this would be your, I'd say, almost entry level. So this is the lowest level of culpability. And unfortunately, you'll see that the starting point for a judge there would be 2 years imprisonment with a category range of 1 to 4 years. If we move back up to culpability, so that's the highest culpability, and that's A, then you'll see starting point at 12 years. And I will touch on a case later on, the case of Greenfeeds, where a director has recently been sentenced to 13 years in custody. So unfortunately, it doesn't make good reading for anybody who's convicted of this offence. People will be going to prison. And I know that we have a trial in the new year, and we've had to advise our clients on that particular matter. Chances are that if convicted, he'd be looking at between 4 and 7 years imprisonment. Okay, could I have the next slide, please? Right. This is the Section 37 of the Health and Safety at Work Act offence. And I call this the director offence. And we'll go through the definition in a minute. But the reality of this is an offence that is invariably reserved for, here's my phrase, the top brass. Okay, legal terminology is people within an organisation that have real authority. Only those people within an organisation that can dictate corporate policy. So they can decide a business is doing something or it's not doing something. And as a rule, if you're in that category, well, yes, you'd be caught by the Section 37 offence. But as a rule, if you have a boss, okay, if you have someone that you report into, then I would typically always fancy our chances of defending that individual and removing them. Conversely, if you are the boss, if you're the person that people report into, more often than not, your fingerprints are over everything. If you're a statutory director, then all day long, you're going to be in this category. And if you're that senior, you are at risk of this Section 37 offence. So let's just have a look at it. Where an offence under any of the relevant statutory provisions, that simply means the Health and Safety at Work Act, committed by a body corporate, so that's a company, is proved to have been committed with the consent or connivance of, or to have been attributable to any neglect on the part of any director, manager, secretary, or other similar officer of the body corporate, or a person who was purporting to act in any such capacity, he, as well as the body corporate, excuse me, shall be guilty of that offence and should be liable to be proceeded against and punished accordingly. Okay, so a bit of a mouthful there, but what it's saying is that if the company has committed an offence, and that's going to be an offence under the Health and Safety at Work Act, so that's typically going to be the Section 2 offence, which is the duty a company owes to its employees, or the Section 3 offence, which is the duty a company owes to any person that's a non-employee. Excuse me. If the company is said to have breached the law, and that's attributable to the conduct of one of the directors or one of the owners, then the individual, or one or more of those individuals, may be investigated and prosecuted as well as the company. Okay, and effectively the focus there by the regulators, and it'll be typically the health and safety executive, it might be the local authorities, could be the Office of Rail and Road, but whoever the health and safety investigator is, they're going to focus on these three words that I've put in bold. That's the consent, connivance, or neglect of the director. And this always causes me difficulties as a defence lawyer, as a criminal defence lawyer. Consent, connivance, I'm relatively comfortable with, because consent effectively means that you knew of the risk and you've approved it. Okay, but there's knowledge there, so you know of that risk, you've given it the thumbs up. Connivance, that's willfully turning a blind eye. but there's still knowledge there. So there's a part of me thinks, well, at least the allegation is suggesting that the individual knew what was going on. And that's that you know about the risk, but you thought, you know what, I know this is risky, but I don't want to have any involvement with him. I'm leaving site. I've left instructions. I don't care how you get this done. Just make sure that work's done by the end of the day. Again, there's knowledge there, but you willfully turned a blind eye. Well, this next one. This is the one I'm most uncomfortable with as a defence lawyer, and that's the concept of neglect. And neglect for the Section 37 offence does not require knowledge. And the vast majority of criminal offences, be that drugs, violence, sex, all the dishonesty offences, they all require the defendant to have knowledge, to have criminal intent. That's not the case here for the neglect element. And effectively, the allegation will be that you ought to have known about the risk, or that you ought to have done something to control that risk. Okay, so it's effectively through your omission, through your neglect, something that you've not done. That's where the focus will be if the investigators are looking at this particular offence. And then if we look in the bottom left-hand box there, you'll see that the maximum penalty for this is 2 years imprisonment. What you will more often than not find, again, you'll see it in the convictions later on, you will typically find that if there is a prosecution for an offence of gross negligence manslaughter, there is frequently a Section 37 alongside it as well. And what there will virtually always be is a prosecution of the company also. It's not a necessity in law, but I have never seen an individual prosecution where the company has not been prosecuted also. So certainly for health and safety, the two go hand in hand. The company gets prosecuted and the individual gets prosecuted for either gross neg manslaughter and Section 37, or simply a Section 37 offence by themselves. Now, the company is normally funded by an employee's liability or public liability policy, although in your case, as mentor customers, you get £100,000 worth of coverage, which is excellent. That's normally more than enough. But unfortunately, if we do find ourselves in a manslaughter trial, be that gross negligence manslaughter or corporate manslaughter, then £100,000 isn't enough. And it's certainly the case that we effectively will run to several £100,000, sometimes into the low millions when it comes to the legal fees. Okay. Now, based on that, I move on to this third box. Okay. That's directors and officers cover. Whilst all companies in law are required to have an employee's liability and public liability policy, so it's not the case that we ever see companies without them, and you've got the mentor policy, it's not the case for individuals. And I routinely see individuals who do not, these are directors, senior managers, who do not have the coverage to allow themselves to be properly represented, particularly through the investigatory stage. And that can last probably 3, 4, 5 years before a decision on prosecution. And they don't have the legal coverage. And that to me is probably where you need it the most. So I simply flag that as a heads up. If you find yourself thinking, well, this could be me, if there was, God forbid, a workplace fatality in your organisation, and I might be subject to investigation and prosecution, then please ensure you have sufficient funding to cover your legal defence, and that's typically under a D&O policy. Okay, could I have the next slide, please? So dealing with the Section 37 offence, again, here's the table that the judges would have in front of them. This is taken directly from the Sentencing Council's guideline for health and safety offences. And if you can just go to, I'll say, a quarter of the way down, so it's to the band that says high culpability, it's certainly my experience, over 80% of the cases I deal with and my team deals with, that's where the prosecution will start. High culpability, harm category 1. Okay, I've never seen anything in the very high culpability. I've never seen anything in the low culpability category. So it's these two middle bands that we typically see, high culpability and medium culpability. But you can see high culpability, harm category 1. Starting point there is 1 year's custodial, and the range for a judge will be from 26 weeks through to 18 months. So 6 months to 18 months is the range. So again, this is not a trifling offence. People are sent to prison for it. Okay, could I have the next slide, please? Right, here's another individual offence, and this is born out of the Section 7 duty, Section 7 of the Health and Safety at Work Act 1974. This is the duty that applies to every single employee. So that will include directors, but it will also include every other employee within the organisation. So anybody that has a contract of employment with the employer is caught by the Section 7 duty. And let's just have a look at it. It should be the duty of every employee while at work, A, to take reasonable care for the health and safety of himself and of other persons who may be affected by his acts or omissions at work. Okay, let's just look at that. That's a duty that every single employee has to look after themselves and to look after anybody else that might be affected by their acts or omissions at work. And this phrase, acts or omissions, we see a fair bit. I'm bound to say that I tend to find that omissions is where there's more activity. An act is something positive, an act is something that you've done, whereas an omission is typically something that you've not done, that you failed to do. And in health and safety, again, it's certainly my experience that omissions are more prevalent than acts. And in this sense, we've got this duty in law that employees must take care for their own health and safety, okay, and for others. So I think that's very important, and I'll touch on it after we've been through 7B, okay? 7B states, as regards any duty or requirement imposed on his employer or any other person by or under any of the relevant statutory provisions, they have a duty to cooperate with their employer so far as is necessary to enable that duty or requirement to be performed or complied with. What that means is that if the employers, if the business puts things in place to keep employees safe, the employees have a duty to cooperate. So if you give them PPE, they have a duty to wear it. If you give them fall arrest equipment when working at height, they have a duty to observe it. If you give them a safe system of work and you instruct them on it and it's properly maintained, they have a duty to observe it. Okay, so if they don't do that, then they fall foul of 7B. And if they're not looking after their own health and safety, they fall foul of 7A. And this is always my challenge to organisations, to employers, particularly when working with your HR department. And if you're a smaller business, chances are you won't have an HR department. You'll work closely with Mentor through the HR function. But for those of you with a bigger organisation where you do have somebody responsible for HR, then please let them see Section 7. Because whilst I can't sit here and tell you that there are lots and lots of prosecutions for this offence, and that annoys me a little bit, there's not. They are like hen's teeth, prosecutions for Section 7, which I find desperately frustrating when I see how many of the cases I deal with did involve fault on the part of an employee. But what I encourage employers to do is see if they can discipline employees that fail to take reasonable care for themselves or fail to observe what the company has put in place to keep them safe. There's a breach in law. If you can establish that in law, then my challenge to HR practitioners, surely you can establish some form of disciplinary action to be taken against the employee. And please, that's not me in the hang 'em and flog 'em brigade. I'm not saying you dismiss everybody, but it's perfect, I think, to actually bring people in for disciplinary, and it enhances your culture in respect of health and safety. And certainly from my point of view, if ever I've got to represent a company where there's an allegation against the company, a health and safety breach, then if I can see that there is evidence that they have disciplined people for health and safety breaches in the preceding 2, 3, 4 years, that really is gold dust for me as a defence lawyer. So you can hopefully see, I think almost on a moral side, I think you're doing the right thing. If they're not looking after themselves and they're not looking after other people, it's a bit like a parent with a child. You have to chastise them. You've got to stop them from doing something that's putting themselves at risk. So there's the moral side. And then more the hard-nosed defence lawyer, which is, well, I like it because it helps me defend my clients if there is an episode in the future. Okay, could I have the next slide, please, Paul? Right. Directed prosecutions. I've clearly mentioned the Section 37 offence. I would, simply like to give you maybe a flavour of the kind of themes that I've seen over the past 20 years, and I've seen with a degree of frequency. And unfortunately, and this is for all of you in the SME space, and I know that is a large number of the mentor customer base. So SME being small to medium enterprises, and also the micro businesses, which are even below the small businesses. What I'll typically find is that you'll have the directors. They are proximate to the incident itself, okay, and it's usually their decision making, or it could be their acts or omissions, that are the focus of the regulators when they're dealing with an investigation into a death or a serious injury. So it's that concept of proximity. And the reason I believe that's the case is that very often with SMEs, that they'll have been built up typically by a very dynamic leadership team. It could be an owner manager, it could be a family, but more often than not in a small business, that director, he or she is still, hear my phrase, on the tools. They're at the coalface, they're leading from the front. And what that means is they've got proximity, they've got their fingerprints on everything that's going on in that business. And it therefore follows that if there is a serious health and safety incident, then their fingerprints, their leadership style, their decision making will come into the focus of the regulators, and the witnesses will say, well, he's responsible for health and safety, or she's responsible for health and safety, or the pair of them are responsible for health and safety. So that's what I've seen over the years, that for much smaller businesses, then that's where we see the activity for investigations by both the police for gross negligence manslaughter and the health and safety regulators for the Section 37 offence. So it is virtually the domain of the smaller business. And point three there, if you contrast that with the large businesses that we act for, and look, we act for several multi-billion-pound global businesses, retailers, construction, manufacturing. It just won't happen. Okay, their directors will not be the subject of investigations or prosecutions. Highly unlikely, and it's because it's got several layers of management between them, at the top table on the board and the coalface. It's rare they'll even be in the same location. Probably the incident's taken place at a manufacturing site in Cumbria. They're sat in the head office in, who knows, Birmingham or London. So in that sense, it's something that I see as a theme, and without exception, all of our gross neg manslaughter prosecutions and investigations are for small businesses. Okay, and I know we've got two in 20. We've got one in 2024 for trial, one in 2025. So these are both gross negligence manslaughter, and that's involving directors. Okay, so they're being prosecuted for the gross negligence manslaughter offence and the Section 37 offence, as well as the companies that they're directors of, and they are both small businesses, as in less than 10 million turnover. Okay, and from the point of view of other things that I've seen, again, I think SMEs, it's rare that they've got, I'll say, sufficient health and safety assistance, and this is point 5 we're looking at. The law requires every organisation to have effectively competent persons, so it's called Regulation 7, the Management Health and Safety Work Regs. So you've got to have competent persons who are providing you with assistance on your health and safety, on how you comply with health and safety legislation. Now, that person doesn't have to work for you, doesn't have to be within your organisation, and that is why you can effectively use the services of consultancies such as Mentor. You can have people within your organisation, but either way, the important point is that I think for smaller businesses, it's rare, in my experience, that they've got sufficient health and safety knowledge or support. And that's the ones that clearly I see being investigated or prosecuted. So in that sense, I would always encourage the smaller businesses to really double down on your health and safety, to be comfortable that you do have sufficient experience and knowledge within your business, or you're effectively buying it in. And when I move on to point 6 there, this is me being either, well, I'm trying to be polite. I see with the smaller businesses or with the directors when I've had to deal with them, there's either an ignorance, okay, which is that they just think, okay, it's not me. I've paid for some health and safety consultancy services. That now suffices. Or actually, yeah, I brought so and so in. They've got a health and safety qualification. I pay them to be a production manager, but by the way, they've got a health and safety qualification as well. That'll do, and they can carry the can. Not so. Okay, it's a non-delegable duty that is owed by the employer of that business. You can use other people, you can use expertise within your own business, you can use the consultancy services, but you would be incorrect to think that you can somehow outsource it. It is a non-delegable duty, and the employer must comply with the health and safety duties under the Health and Safety at Work Act. The other side to that, and I'm about to say, I have seen it, it's just sheer arrogance, okay, which is, I've paid for that, I've got this glossy health and safety file that's been sent to me by my consultants. I've paid for that individual to go on those courses. It's not me. And I've got to be honest, it's rather unpleasant when I encounter that kind of individual, because by that stage that they are typically looking to me or my team to probably keep them out of prison. All right. And the penny finally drops with them. But quite often, not quite often, I have seen it, it's why I mentioned not quite often, but I've seen it. It's born out of arrogance. It's born out of the fact, which is, well, I'm not dealing with this. I'm paying somebody else to do it. Okay. And then finally, something I see all too frequently and that I've seen over the years, but it's this concept of a lack of challenge or a lack of accountability. I've touched on it a couple of minutes ago. Look, some of the fantastic businesses we see, incredibly dynamic, very successful. They've got to where they are because of this really strong work ethic and dynamic leadership. But quite often those people are pretty autocratic, and they've got to where they are by taking no prisoners. But in doing so, they may have forgotten to surround themselves with people that give them sufficient challenge, and that may be on health and safety. Okay, and that kind of individual sometimes will just say, well, no, we're going ahead. It's all about sales. It's all about production. The bottom line's everything to me. And they forget to, if they don't forget, they certainly don't pay anywhere near sufficient attention to the fact that to do law in the UK, you've got to be compliant with the Health and Safety at Work Act. Oh, sorry, to do work within the UK, you've got to be compliant with the Health and Safety at Work Act. So that's that autocratic style. They don't receive sufficient challenge. And the other areas I've seen over the years will be families, whether it's a husband and wife, whether it's a mum and dad and the two sons, whether it's three brothers. And these are all cases. So these are cases, all Section 13(7) and gross negligence manslaughter relationships as I'm referring to there. And common theme is there was insufficient challenge. They're working as a family. They're all looking to make sure that the business gets better, but they don't challenge each other. They don't stop and say, well, hold on, you need to do more about that in respect of health and safety. And I suppose it's just that family relationship and the complacency that potentially creeps in is that will you pick up one of your loved ones in the way that you would one of your work colleagues that's not done something wrong? And I don't know, maybe you would, in which case you can sort of discount what I'm saying. But if not, and you think you're in that kind of business, then I would simply ask you to revisit that and how you actually deal with family members if they've not done something which they should have done, if there's been acts or omissions around health and safety. Okay, next slide, please, Paul. Okay, here is these are just three cases that I've put together. These are recent direct convictions, so it'll tie in with the offences we've just been talking about. Deco Pack, 24th of April 2023, Leeds Crown Court. This related to an employee crushed to death by a robotic packing arm while attempting to clean a sensor on the automated backing production line. One director was sentenced to imprisonment for 5 years, so that's clearly going to be for gross negligence manslaughter. and the total length of that case from date of incident, so that's when the investigation would have started, through to conclusion, and there was a trial and a retrial there, that's 5 years. So that's 5 years of his life dealing with that particular investigation, and then another 5 years of his life where he's going to be in prison. Although, look, he'll get early release, okay, but he's still going to serve well over half of that sentence. Excuse me. Right, number 2, green feeds. This is the one I mentioned earlier on. 16th of June 2022, at Leicester Crown Court, death of 2 employees who drowned after falling into a tanker containing semi-liquid pig feed. They were attempting to clean it with a power hose. I know that one went in, he was attempting to clean it with a power hose. The other probably gone in more as a rescuer, okay? But what a tragic case. On that occasion, the director, she was sentenced to 13 years imprisonment for gross negligent manslaughter and the Section 37 offence. Her husband, who was a co-director, he was sentenced to 20 months imprisonment. That's for the Section 37 offence alone. And that particular case, again, from date of incident with the criminal investigation, that one involved the police and the health and safety executive. That was for 5 years. Plus, there was a 6-week trial. And you can see this individual, who I know was in her 60s, she is not getting out of prison for quite some time. Okay. And then finally, number 3, just total contractors, 9th of June 2022, Lewes Crown Court. Employee had been using a ladder secured by 2 nails into a timber frame when he fell, causing fatal injuries. One of the directors there was sentenced to 5 years imprisonment for gross negligence manslaughter and the Section 37 Health and Safety at Work Act offence. Another director, co-director, sentenced to 15 months imprisonment for the health and safety offence. Again, that case was nearly 4 years in length. I'm not sure how long the trial took, but you're seeing a theme here, okay? And I'm not being flippant because pride comes before a fall. None of those are our cases, but from the point of view of the fact that people are prosecuted and sent to prison, if convicted, you will see that they're going to prison for quite some time. Okay, could I have the next slide, please, Paul? Okay, I just want to touch on this offence, corporate manslaughter and corporate homicide. That's the act. Corporate manslaughter is what the offence is called in England and Wales. Corporate homicide, simply the same offence, but that's its name in Scotland. So we're not dealing with 2 offences. And let's just look at the definition of the offence. And forgive me, before I go any further, I'm going to take all the way to the bottom, and you see the asterisk there, Section 18. An individual cannot be guilty of aiding, abetting, counselling or procuring the commission of an offence of corporate manslaughter. So before we go any further, I know we've been talking about individual offences, and I've probably depressed you enough already. So the good news is nobody can go to prison for this offence. The clue's in the title. It is a corporate offence. So it is only companies that can be investigated and prosecuted and convicted of this offence. So there's the good news. But let's just look at what the investigators and what the prosecutors have got to do to get home on this offence. Section 1.1. An organisation to which this section applies is guilty of an offence if the way in which its activities are managed or organised, A, causes a person's death, and B, amounts to a gross breach of a relevant duty of care owed by the organisation to the deceased. But trust me, in a workplace setting, that's not going to be difficult. That's not a problem for the investigators or prosecutors. There will be an employer-employee duty there. But if we look at Section 1.3, an organisation is guilty of an offence under this section only if the way in which its activities are managed or organised by its senior management is a substantial element in the breach referred to in subsection 1. Right, so the company commits the offence through its senior management. So that's therefore got to be the focus of the investigators, which is right. So we're looking for senior management failure for this offence to be committed. And if we then look at the definition of senior management, Section 1.4c, senior management in relation to an organisation means the persons who play significant roles in Roman numeral 1, the making of decisions about how the whole or a substantial part of its activities are to be managed or organised, or Roman 2, the actual managing or organising of the whole or a substantial part of those activities. Right, I think we can probably all agree that Roman numeral 1, that's the making of decisions about the whole or a substantial part of the activities. That is the top brass. That's your board of directors. It's the main board. It is what we would typically associate, I'd say, with your senior management team. But if we then look at 2, the actual managing or organising of the whole or a substantial part of those activities, well, that's going much lower into a business. That would be regional. It would be site-based, and even it would be departmental-based. So even if you are a single site, you're a smaller business, that could still even be within a department within your small business. And the example that I'm going to give you as to how deep into an organisation the investigators will go, will probably show how these cases are investigated. Now, because it's corporate manslaughter, the law requires the police investigate this offence. Likewise, the earlier offence of gross negligence manslaughter. The health and safety offences get investigated by the health and safety regulator, so HSE or local authority typically, but the manslaughter offences are led by the police, and it's not the uniformed police, it would be CIDs, that's the detectives. So previous day they would have been on murder, people trafficking, rape, the most serious of criminal cases. So they are first-class investigators, typically detective inspectors or detective sergeants, and they investigate these offences. And for corporate manslaughter, they're looking for senior management failure. And the example I can give where they focused on what they classed as senior management relates to an incident that was in Huddersfield. I had to act for an individual there rather than the company. So it's their company solicitors asked me to deal with him. And he was an hourly paid colleague on the minimum wage. Okay? Hourly paid on the minimum wage. And he had to spend 7 hours in custody at Huddersfield Police Station because West Yorkshire Police were investigating the corporate manslaughter offence. And they were of the view that he fell within the category of senior management for the purposes of their investigation. And the reasoning behind that was that, tragically, a 17-year-old apprentice had died in a baling machine in a manufacturing site. And it was my client that had said to him, go and put the cardboard in the baling machine. And that was the last time anybody had seen the deceased. So my client was being focused on effectively because he had put the deceased to work. He had told him, go and put the cardboard in the baling machine. Now, the good news is that my client, that was the last I saw of him on that day. And I said, there's not a cat and hell's chance this is going anywhere. But the point is the police were entitled to investigate, and they look at my client for gross negligence manslaughter in Section 7. That's what he was actually arrested for. But from the point of view of their focus, it was all about the focus on senior management for the company. Okay. So what I have seen over the years is that the investigators, they cannot arrest a company because it has a legal personality only. They can't arrest the company. They can't say, can you come to a police station? They can't put handcuffs on it. So what do is they look to question the senior management. They focus on the senior management's decision-making, their acts or omissions. And here's my phrase, they shake down the senior management. And what you'll actually see when it's senior management, from the example I've just given you, it's not senior management at all. It's anybody that's making a decision within the organisation. And that's what the police can and do when they're investigating the corporate manslaughter offence. So God forbid, but if you do find yourself in the sort of the crosshairs of a corporate manslaughter investigation following a workplace fatality, then please be alive to the fact that it will be your acts and omissions, your decision-making that's likely to be the subject of scrutiny by the police because they're looking at this corporate manslaughter offence. Okay, and that concludes my section, Paul.
Chris, fantastic. Thank you very much. Got loads of questions coming in. I'm just going to hand straight over to Kevin.
Thank you, Chris. That was excellent there. So as a senior health and safety consultant with Mentor Services and as part of our crisis management services, I work closely with our partners in Clyde & Co to support a number of our mentor customers in dealing with some serious incidents. Crisis management, it's part of our service that we hope none of our customers will ever need to use. You can imagine from what Chris was talking there. But in my mind, to those customers trying to deal with such crises, it's probably a godsend just to have that hands-on support at such a stressful and difficult time. A key point for us is to involve our partners in Clyde & Co as soon as possible. So when a serious incident happens, we cannot make it unhappen. We can, however, look to manage and control the situation, keeping it under control best we can. And we find this immediate period just after a serious incident is where our customers really, really need our support. And often that is where many unnecessary serious mistakes are made. Next slide, Paul. So I think it's important just to point out that the offence of gross negligence manslaughter, it does not exist in Scottish law. The closest equivalent offence in Scotland is that of culpable homicide, and that's an offence that's often thought of as the little brother to the offence of murder. So we're just one down from murder here. In Scotland, for the prosecution to prove a charge of culpable homicide, they would need to establish that the accused committed an unlawful act, and that unlawful act was intentional, or it was reckless, or it was grossly careless, and the death was a direct result of that unlawful act. Now, that's in stark contrast to the gross negligence manslaughter offence that Chris was talking about in England and Wales. What that means is that the legal bar for convicting individuals of manslaughter is much higher under Scottish law, but there's also a consideration of the public interest required for the prosecution for any conviction to succeed. So there is an argument that the Scottish law approach may be a fairer legal test of negligence, and that's maybe something for another debate. So as mentioned before, after a serious incident, we do like to get our senior consultants involved as soon as possible. Often that's under a legal privilege instruction from Clyde & Co to undertake incident investigations and begin mitigation work to defend our clients. But let's talk about health and safety responsibilities, and I see there's one of the questions that have come in is about this actually. So we all know that managers at all levels can assign health and safety responsibilities to other persons within their business. However, it's maybe not as well understood that whilst managers can give responsibilities, they cannot give away their overall accountability under health and safety law. And that is often a problem at senior level. For instance, under a gross negligence manslaughter or Section 37 prosecution, it could be argued that the most senior managers did not know about negligent ongoings in parts of their business. However, often the case, really, they should have known, and that's neglect. You know, that's the omission offence that Chris was talking about early on. Most businesses we deal with, they are very, very good at what they do. That is why they're in business. But often they will struggle to prove so with respect to compliance with health and safety law. We often find that small, medium enterprises in particular, they frequently have insufficient evidence available to prove they're effectively managing health and safety. And suddenly all of that boring stuff, like they were too busy to worry about, like risk assessments, method statements, training records, etc., that all becomes really quite important. But actually, we often find that larger organisations, they can also struggle to provide sufficient evidence to prove they're effectively managing health and safety. I do take the points that Chris makes about several layers of management between the directing minds of the larger businesses and an incident. However, in our experience, often larger organisation management structure is heavily production orientated, and the management of health and safety, it can be, no other word for it, it's dysfunctional or very often massively under-resourced. And senior management can often take little interest in day-to-day health and safety issues, leaving everything really just to lower or middle management. Next slide, Paul. So if we ask ourselves, what can directors do now? Well, when a company is accused of a breach of statutory duty under health and safety law in either a criminal or a civil court, then actually we do need to gather evidence to prove that the company is operating within the guidelines of the Health and Safety Work Act and associated regulations. Similarly, with accusations of individual negligence at director and senior management level, it greatly helps to have evidences of the management of health and safety being driven from director or from board level. Our advice, well, my advice to directors is that, well, if I was a CEO, if I was a managing director, I'd want to know now. You may want to consider engaging a confidential external audit just to sense check your current management systems. Now, that's probably the one thing that I would recommend that you take from my small part in this webinar. Doesn't need to be mentor, but use an external auditor just to give you an unbiased, independent view. I suggest that you maybe want to look at your current management structure, the roles, responsibilities for health and safety. That's not your line management structure. It's the job description, role, responsibilities. And often it just doesn't make sense. I mean, often health and safety is left to one or a few persons in the organisation, and they tend to overcompensate for other line managers rather than line managers at all levels taking responsibilities for areas under their control. I mean, our evidence that health and safety is directed at senior level, and is there evidence that there's meaningful consultations ongoing within the workforce? I mean, do your senior managers get involved in health and safety? For example, is health and safety discussed at board level? Do senior managers get involved in things like regular workplace inspections, etc.? Things tend to happen in organisations because they're allowed to happen. And you might think that that's a harsh statement, but it's true. I mean, the health and safety culture of any organisation is driven from the top. So, as a director, do you have visibility of the effectiveness of your current management systems? Have you looked at the documentation? Is your health and safety policy fit for purpose? Has it been reviewed? Do you have risk assessments, method statements, training records, etc.? All the stuff that Chris and I would really like to actually see for your defence. Do you have evidence of compliance? Is there evidence of regular workplace inspections, checking that your risk assessment controls are valid? Are you doing internal audits? Are you doing external audits? Have you got evidence of disciplinaries for health and safety breaches, as Chris touched upon there? Red flags wise, for us, we'll go into organisations, sometimes there's no risk assessments, there's no method statements, there's no efficient management procedures, generic documentation, not signed off by local managers or a site level, activity level, So in summary, I advise actually that for the director, senior manager, it's often better just to look into these things now, understanding as we do director individual health and safety liabilities. If it was me, I really would want to know now. Paul, thank you.
Fantastic. Thank you, Kevin. Ladies and gents, I did say we were bringing out the big guns for this webinar. So, yeah, Lucy, lots of questions I see. Over to you.
We've had lots of questions. Thank you, Paul. Thank you, Kevin and Chris. So, Chris, what were the key failures of the directors for which they were imprisoned in the examples you gave? Can you just give us some highlights? I appreciate you can't go into full details in all those cases, but any top tips there?
Right. Unfortunately, that none of them are my cases. Okay, but what I would say in respect of the Greenfeeds case, it's my understanding, just from people who know what were involved, is that they'd had a not dissimilar incident previously. Okay, so in that case, they and this just, you can't quote me on it, but I think for the purposes of that example is if you're already on notice of a risk, okay, and let's say there'd been a previous incident, then you're certainly on notice of the risk or something similar. If you're on notice of a risk, yet you decide that you're still going to continue, or your business is still going to continue to run that risk, and the risk materializes and 2 people were killed, then you are going to prison for a long, long time. Okay, so in that sense, it's typically, I think in that one is if they've got the knowledge and they're aware of it, then all day long the prosecution are going to focus and say that that was grossly negligent. Okay. Now one that I have been involved with recently, this was a fatality of ours. We had 2 directors, and one was acquitted of the Section 37, and we pleaded guilty to another. This was our other director. He pleaded guilty to a Section 37. We got him a 180-hour community sentence. And the criticism and the basis that we pleaded to, and that was on a fatality. We got the fatality removed, but he pleaded guilty on the basis that he had not adequately managed the contractors that he was using in his business. Okay, he'd not done enough. Now, again, it was the neglect element that they went after him for. So they couldn't prove that he knew, wasn't on notice, but it was, well, hold on, you're a director. You should have been doing more because you appointed these contractors. Excuse me. You should have been checking them. You should have been monitoring them more than you were. And unfortunately, there was a fatality there. So I hope that gives you a flavour of the kind of things they'll be focusing on. So
Absolutely.
knowledge of the risk, or effectively what you ought to have done, which is the neglect element.
Thanks, Chris. Yeah, and echoes what Kevin was saying about having those processes in place, those management audits, really taking those responsibilities seriously, having a great culture with regards to health.
Sorry, Lucy. Forgive me, Lucy. I'm going to interrupt there. Wow, the audits, and just if you're going to do the audit, please then act on it. If you're not going to act on it, don't get an audit. Okay, because that's dynamite. And one of the cases I've been involved with, going a few years back, they used the auditors. This is the Crown Prosecution Service brought in the auditor as the #1 prosecution witness. That was in a corporate manslaughter case called Lion Steel. Okay, probably about 10, 15 years ago. So please don't get an audit to then just ignore it. You'd be better off doing nothing. Sorry if that's not doing anything for mentors auditing services, but hopefully you get my point.
No, absolutely. Yeah, the critical bit is the risk assessment, isn't it? Identifying it and knowing what risks you are facing and how you can mitigate those. We've got a couple of technical questions here. If we can quickly whiz through those. If the company is based in Scotland, but the incident happened in England, what state's law would it fall under? And vice versa?
Yeah, the incident would take place in England. It will be investigated. So let's say it's a fatality. It's going to be investigated by the, let's say it took place in Birmingham. It's going to be West Midlands Police are going to investigate alongside of it, depending on the industry you're in. It's going to be the HSE. They'll investigate and they'll prosecute and they'll have a trial in Birmingham Crown Court. The Scottish directors will have to come and have their trial in Scotland. And the same would apply. So if we had a Birmingham company and the incident's taking place in Edinburgh, then it's going to be the Scottish police and effectively the HSE or the local authority, depending on the industry sector.
Excellent, thank you. We've also had a question about staff working from home. Where do businesses stand with regards to health and safety in that situation, please?
Okay, well, look, we saw a lot of this during COVID. Work from home, provided you're doing you're providing with for me, it's the display screen equipment risk assessment, so that the posture's correct. You're making sure that they've got the right equipment, so chairs, desks, all that kind of stuff. As far as I'm concerned, that's where it stops. Okay, as long as you're doing that, and we class that in health and safety, that's a health risk. Okay. Whether they're going to get musculoskeletal disorders, that's the risk. And look, I'm a lawyer. I sit at a desk most of the day. That's the most risky thing I'm going to be doing. There is absolutely no need to be undertaking risk assessments of your employees' homes. For starters, you as an employer have no control whatsoever over the site. Okay, and secondly, and it's this concept of unintended consequences. Look, sending a person in to undertake a risk assessment in my house, okay, that's going to be increasing the danger to the risk assessor. You are introducing far more danger than even exists to the person working in their own house. And so there's absolutely no risk of the HSE or local authorities investigating for episodes. If someone falls down their own stairs because they're carrying a laptop and they're doing something stupid, please, that is not coming anybody's way from the point of view of a health and safety investigation.
Lucy?
Thank you, Chris. That's wonderful. Yes, thank you. I'll hand over to you, Paul. Thank you.
Ladies and gents, we've now come to the end of an hour. If we didn't answer any of your questions, I've left the details on the screen. Please reach out to us. More than happy to answer any questions offline. And like I say, if you do the survey, you'll get a copy of the slide deck and we will send you a link to a recording of this webinar. But from me, Lucy, Kevin and Chris, thank you very much. Wishing you all the very best for Christmas, New Year. And Lucy, we're going to do this again in 2024, I believe.
We absolutely are. Look forward to seeing you all then.
Fantastic. Take care, everybody. All the best.
Thank you. Bye-bye.
Thank you.
Do we stay on, Lucy, or is that us? Is that it?
Oh, Paul's inviting us to another meeting.
Right, okay. I'll log out and go back to that.
Perfect.